Hello, this is Kato again. I am here to resume our discussion about sound management practices with respect to managing employee performance and of terminating the relationship when necessary. So this is Kato again. I am the owner and operator of my own law practice here in San Francisco, advising employers in all aspects of employment law. So what I want to lead off with today is what I refer to as common management practices that can backfire in a legal proceeding. And one of those, and the most critical one, is where an employer succumbs to the notion that I'm going to go into I'm the manager, I'm going to go into the meeting with the employee where I'm going to give the employee a performance improvement plan, but I'm also going to suggest as part of that meeting that perhaps it may be the best thing for that employee to think about and accept a severance package for his or her voluntary resignation. Now, I'm fairly certain that this happens quite a bit, and frankly, it oftentimes will go forward where the employee may accept the package, sign a general release, and you're done. We're not faced with a legal dispute over that later, and we've also avoided the necessity of having to go through a performance improvement plan process with that employee. But let's say it doesn't go that smoothly, and in fact, the employee says, no, I don't want the severance package. I'm not going to voluntarily resign. I think I'm a good performer and that I can satisfy the terms of the performance improvement plan. So what do you do with that? What's the legal issue? Well, the problem is that assuming the employee does take the performance improvement process or the plan and the employee fails the performance improvement plan and is later terminated. Let's also assume that the employee sues for some form of wrongful termination, for instance, for discrimination. Now, what happens in this type of a scenario, or what can happen, and I just say it happens because it's almost inevitable that the employee's attorney will take advantage of this to try to buttress the case. That employee's attorney is going to point back to that meeting in which the manager offered the option of either taking the performance improvement plan or the severance package. The attorney will point to that severance offer as so-called proof that the employer had already made up its mind, in other words, that the performance improvement plan was a sham. And if then, as a result of that assertion, the jury then believes that the performance improvement plan was, in fact, a disingenuous offer, then, again, the employer is in a situation where the jury may turn against the employer. And this is the sort of thing that can happen where the performance improvement plan is offered the same time as a suggestion that he or she, the employee, resign. So as a result of that, or to avoid that situation, I've suggested the solution and what I refer to as the better approach, which is, first of all, only place the employee on a performance plan, improvement plan, if there is indeed a reasonable chance that the employee can succeed. So if in fact even the supervisor and the rest of the management team does not think that the employee has a reasonable chance of being able to turn his or her performance around, then my response and recommendation at that point is don't offer the employee a PIP. don't offer the performance improvement plan because it's not reasonable. It can be viewed as disingenuous. Just go immediately to termination rather than go through what the employee's attorney would refer to as a sham performance improvement plan process. So if you decide that, well, no, we think there is a reasonable chance that the employee can, in fact, turn his or her performance around if we do give the employee notice and opportunity to improve, then in the meeting where that performance improvement plan is delivered, don't suggest that the employee resign. Now, conversely, let's say after delivering the PIP that the employee says something to the effect that, you know, I really don't think that I'm a good fit for this job, and would it be possible for me to exit gracefully and submit my resignation? Then yes, immediately accept that resignation, and in fact don't let that employee rescind or take back the resignation if he or she has second or doubts about that resignation at a later time. So with respect to the severance package notion, don't offer a severance package unless and until the employer has already decided to terminate the employee. First of all, you don't have to offer a severance package at all in a situation where the employee is being let go for unsatisfactory performance. But if you want to do that, and there's nothing unlawful per se about that, if you're going to go ahead and do that, then do it at the point of termination, not in conjunction with offering this so-called option to take the performance improvement plan or to resign. Now, it's okay in the context of the termination meeting. In other words, we're not giving the employee an option. We're going to let the individual know that he or she is being terminated. It's okay in that setting to tell the employee as a what I refer to as a face-saving measure to say, if you want, you may resign, and that your personnel file will reflect that you resigned instead of being terminated. But it's your choice. Now, even if the employee says, okay, I would, yeah, that would be helpful to me going forward, so yes, let me resign gracefully. Now, your internal human resources documentation should, in fact, continue to accurately record the facts that were the basis of the separation, even if the personnel file shows that the employee, quote-unquote, voluntarily resigned. Now, one thing that we need to cover is that if, in fact, you do go through the process of offering a severance package and employee accepting and perhaps negotiating as part of that he or she will have, quote-unquote, voluntarily resigned, and that his or her file would reflect a voluntary resignation. One of the things that's important, particularly in this time period, is to reserve the right to respond truthfully to any government inquiry about the reasons for the employee separation. And what is this all about? Well, primarily the inquiry about the reasons for the separation may come from your state's agency that administers the unemployment insurance program. And it's not uncommon now to receive inquiries from that agency where the agency requires that employer to explain the reason for the employee separation under penalty of perjury. Now, what this is all about is that as a result of a change in the law, federal law, the Federal Unemployment Insurance Integrity Act, that went into effect in October of 2013. So it's been in place for a while now, but only recently being aggressively implemented and enforced by the state agencies. This federal law change requires the state agency that is administering your state's unemployment insurance programs to be more consistent and aggressive in requiring employers to actually respond to the employee's unemployment insurance applications. Now, I could say that it was fairly common before this law change for employers to largely, perhaps even ignore agency requests for information, or in some settings where the employer has previously agreed with the employee as to how to treat the termination, to perhaps even respond if they wanted to respond with some what I'll refer to as a bogus, untruthful reason for the separation to help the employee to obtain unemployment insurance benefits. That's no more the case. Employers are told by the state agency that they must respond, and because the employer is responding, certifying that the response is under penalty of perjury, then of course what that means is, not of course, but what that means is the employer must be able to respond truthfully to these mandatory requests for information from the state agency. Now, how this usually plays out is if the employee applies for unemployment insurance and states that he resigned, then he's not going to be eligible for benefits. So most employees would know that that's the case and will put down some reason for the termination that would support that individual receiving unemployment insurance benefits. So let's say that the employee states that he or she was laid off for economic reasons. Well, in that situation, that's not true, because you know that the employee resigned pending termination for unsatisfactory performance. So you will need to respond truthfully that the employee was in fact terminated for unsatisfactory performance and was allowed to resign pending that termination. Now, you don't need to get into the gory details about what that was all about unless the agency pushes back for more information, but they will rarely do that. So don't get yourself in a situation where you've committed to the employee that somehow you are going to respond to the state agency request for information with some type of factually inaccurate information, because that is just a recipe for getting the employer into serious legal trouble. So always make sure that it's made clear to the employee in a situation where you're quote unquote negotiating what the file is going to show about the reason for the termination, that the employer reserves the right to respond truthfully to any government inquiry, and then you should be okay. Now, there are going to be examples where, however, I refer to as the performance improvement plan or resign option may actually make sense legally as well as practically. Even though on the previous part of the program, I generally said, don't go this route. There are going to be some, I'll call it fairly rare situations where this is frankly the best way to go. For instance, let's say that you know that the employee is most likely going to resign anyway, and you've heard this through the grapevine that the employee has told perhaps a coworker that he or she is thinking of resigning anyway. In that situation, it may be good sense to go this PIP or resign route, knowing that, again, that the employee is going to most likely accept the resignation option. That's a fairly safe way to go legally. I've also given another example where the employee has already failed to correct performance problems after, for instance, a written warning, and you're still not ready to terminate, and you're going to be ready to go the PIP route, but it may be a good opportunity to have a candid conversation about the employee that, yes, we're going to give you this PIP route if you desire, but it may be something for you to think about to consider a more graceful exit. Now, of course, if the employee does resign and signs a general release in return for some severance, then this approach is legally, as far as I'm concerned, a great success because you've now foreclosed the employee from suing. But as I say here, as a watch out, that if, despite your thinking that he or she, the employee, would accept the resignation option in return for severance, if he refuses and takes the PIP, the performance improvement route, and that employee fails as expected and then sues, again, this PIP or resign option that was offered to the employee may come back to haunt the employer. So it's important to be fairly certain that the employee will in fact accept the resignation offer or option before offering it to the employee. Now, let's talk about what I refer to as special considerations when an employee is accused of misconduct. Now, when we are, again, managing performance to avoid or reduce the possibility of legal liability, I say here that if the employee is accused of some misconduct, you need to resist what I refer to as this temptation to rush to judgment, certainly before conducting an investigation that is appropriate for the circumstances. So if you are not human resources, but one of the operational managers in your company who is listening to this program, I suggest that when this type of situation arises, rather than making the immediate decision, okay, we're done, I'm going to fire this employee who engaged in the misconduct, do involve your human resources, and it may also be appropriate to engage your legal counsel immediately. And the reason why it may be important to engage or involve your counsel is that involvement of counsel may, and I use this word in parentheses or quotation marks, may cloak the investigation and its results with the privilege that your communications with counsel will be protected from further disclosure if necessary and appropriate. Now, I indicate that the investigation should be appropriate for the circumstances. Some investigations are more involved than others depending on the circumstances. At the very least, what you should ensure happens is that you should have an investigator who is unbiased. There should at least be an interview of all the appropriate witnesses. If there's any documentation, they should be reviewed. And last but not least, the employee who is accused of misconduct should be given an opportunity to explain. In other words, to rebut whatever the accusation is. Now, the importance of this is, I think, illustrated by way of an example of a recent case where an employer got into some serious legal trouble over the adequacy of its investigation for alleged employee misconduct. And this was a case called Mendoza versus Western Medical Center that was decided by a California Court of Appeal in January of 2014. So Mr. Romeo Mendoza was a male nurse who had worked at the employer's hospital for over 20 years. Now, by all accounts, he was an excellent nurse. Then what happened was that a new male supervisor was hired. Now, it turns out that both Mr. Mendoza and the new supervisor were gay. Mr. Mendoza complained to the company that the new supervisor sexually harassed him. Now, in response, the employer assigned the next level manager above the accused supervisor to do the investigation. Now, in the investigation, the new supervisor admitted that he engaged in the sexual conduct that was complained about. But the supervisor asserted that the conduct was initiated by Mr. Mendoza and that it was voluntary and consensual. Now, following the investigation, and per the investigator's recommendation, the employer fired both Mr. Mendoza and the new supervisor for unprofessional conduct. Now, Mr. Mendoza then sued for retaliation, alleging that he was fired because of his complaint of sexual harassment. During that litigation, the adequacy of the company's investigation became the key issue. Now, the court, in reviewing that investigation, found it to be problematic. And what were the problems? Well, for one, the manager who conducted the investigation had no training in how to conduct an investigation. And one indication of that was that in conducting the investigation, the investigator interviewed Mr. Mendoza and the new supervisor together and not separately. So Mr. Mendoza said that he was thoroughly intimidated by having to be interviewed with the new supervisor present. Further, the court pointed out that no one else was interviewed, even though Mr. Mendoza had identified at least one witness to the events who supposedly would have corroborated his version of what happened. Now, the court in that setting explained that, and this is a quote, "The lack of a rigorous investigation by the defendant is evidence suggesting that the defendant did not value the discovery of truth so much as a way to clean up the mess that was uncovered when Mendoza made his complaint." So the lesson from this case is that when confronted with a situation where you have an employee who is accused of misconduct, you need to investigate. The company will need to investigate that. And again, the degree of the investigation is going to be subject by the nature of the allegations and the circumstances involved. But at the very least, the company should have a trained investigator complete a thorough investigation, and that this investigation should be done or conducted by the book, so to speak. All right. So this is the prelude to the next session, where we will be talking about other aspects of performance management and termination of the relationship.